I shall start to record. Oh, Tyrone's recording already. Now I'm pressed record as well, so I'll turn my camera off and I'll wait for the, can you share your, well, I'll leave it to you now, David, share your screen or as you see fit.
Okay, I'll share it now. Let me just do that. Okay, hello everybody, and thank you so much for inviting me to give this presentation. Genuinely an honor to be speaking to you all. Already, the 5 minutes beforehand, it's such a lovely community, and I'm really happy that we can be doing this, and hopefully it will be informative, and we can answer some questions that you might have about family law. Okay, thank you. So that's me there. Okay, and I'd just like to say special thanks to Manuela at the RAD as well. Absolutely instrumental in putting all of this together, and super kind and lovely, helping me out the past few days as well. So thank you, Manuela. Okay, so the presentation, it's going to be structured in two main parts. The first part, generally speaking, is all about financial issues. So what you can do in terms of planning for financial issues when you get married or potentially after you've been married, as well as that, what can happen, touch wood, it does for you, but what can happen on divorce, and likewise what the situation is for people who aren't married, for unmarried couples. The second part of the presentation will address the main aspects of the law relating to children, so things like child arrangements, how much time each parent has with their children, as well as other specific issues that might come up, such as a child's name, where they go to school, or if there's any specific medical treatment and objections to that, as well as issues like if one parent wants to relocate, things of that nature. Okay. So the first part of the presentation, then, the financial issues. So if we start with financial issues when two people get married, the general position, and one of the most important things to understand, is that marriage creates an important legal relationship that gives rise to financial claims if there ever is a divorce. And again, touch wood, there won't be. Okay. So one of the most effective ways of planning for the future is by entering into a prenuptial agreement, a pre-marriage agreement. Prenuptial agreements or pre-marriage agreements are becoming more and more popular, especially since a major judgment in 2010. Prenuptial or pre-marriage agreements can provide significantly more financial certainty if you ever do split up. Prenuptial or pre-marriage agreements will never be 100% binding, and a judge will always have some input. But provided a prenuptial agreement is drafted and entered into properly, it is likely to be highly persuasive. So what are the key requirements then for a prenuptial agreement to be as persuasive as it can be? what are the key requirements? One of the first major requirements is that each person has their own independent legal advice, ideally from a specialist family law solicitor. So each person needs to be advised separately. One of the other major requirements is that there's full disclosure of all finances, so assets, incomes, liabilities. What does that mean in practice? It means providing all of your bank statements, all of the details about any properties you have, information about pensions, likewise with the liabilities, credit cards, loans, literally anything you can think of that has a value or is a debt. All of that needs to come out when you're preparing for a prenuptial agreement. One of the other key requirements is that both parties must be entering into the agreement freely. So if there is ever a situation where one person is being coercive or putting a lot of undue pressure on the other person to enter into the agreement, whether there's any kind of inappropriate bullying or threats, things like that, there can't be any of that. Otherwise, potentially, you know, the prenuptial agreement just won't work. The final major point to have an effective prenuptial or pre-marriage agreement is that there should be an appropriate amount of time between when the agreement is finalized and the actual wedding. Typically, that's at least 2 months. So there's got to be a kind of cooling off period. There's got to be some breathing space between when the agreement is finalized and the actual date of the wedding. Okay. A brief note here.
Just interpreters, if you just pause for a second.
Of course.
Okay, thank you.
Okay, thank you. So just a brief note here in respect of how prenups and marriages are also linked to wills and inheritance issues. Wills and inheritance, it's technically a separate area of the law, and we are potentially looking at doing another presentation about that specifically. It can get very, very complicated, but generally speaking, if one spouse were to die, obviously touch wood, and there is a valid will in place, generally speaking, that will determine what happens to the person who's passed away's assets. The will be the main thing. Now, if that happens, but there is no valid will, the spouse who's surviving will receive the deceased's estate, so the person who's died's estate and their assets. If there is a surviving spouse and children, then the surviving spouse will receive the first, currently it's £270,000 of the estate, and any remainder will be divided so that half of that remainder also goes to the surviving spouse and the other half equally to the children. So if there's, say, 3 children, it will go as shares of 1/3 equally. Okay. So moving on to what happens if 2 people divorce and what happens to the finances. Okay. This section is split into 3 parts. The first is just a very brief overview of the divorce process, because it's important to understand that in order to understand what happens to the financial issues as well. Okay. It is important to appreciate that the financial issues relating to marriage are primarily dealt with as a result of divorce. Okay. Divorce can be an upsetting thing to think about, but financial issues normally only arise if there is a breakdown of the marriage. Even if you are divorced, the financial claims that you and your former spouse have against each other will, generally speaking, continue until a formal court order is made. That is something that's really important to understand, because quite a few people will divorce, but they'll never deal with the finances, or they won't deal with the finances in a binding way. The formal court order about finances is therefore very important. It can be made by agreement, which is called a consent order, or as a final order made in formal court proceedings. So by a final order, I mean an order made by a judge. In order for a consent order or a final order to be made, one spouse must have already made an application for divorce. And that's the importance of what I've just been saying. You can't deal with the finances without there being a divorce happening at the same time. The two things are linked. So I'm just going to talk briefly now about the actual divorce process, just very briefly. It only deals with ending a marriage. It does not end the financial claims a person and their spouse might have against each other. I've made this slide just to show briefly where the two things are linked. So there's the divorce form, the other person acknowledges that, and then there's something called decree nisi, which basically just means first divorce order. Once it gets to that stage in the divorce, you can then have the finances formally sorted out. So financial issues can be dealt with once decree nisi has been made in the divorce process. Finances can be resolved either by agreement, so a consent order, or by a final order in the court process. So the consent order process sorts out finances by agreement if two people are divorcing. And I should also add that when I'm talking about marriage and divorce, that applies in almost exactly the same way if we're talking about a civil partnership and a dissolution of that civil partnership as well. In this slide, I've just used the words marriage and divorce just to simplify things. Okay. So if you do divorce, but you don't obtain a consent order, so an order by agreement or a final order in actual proceedings in a court, then you and your former spouse will still have financial claims against each other. Consent orders, they deal with financial issues and are binding once they're approved by a judge. Generally speaking, there are no court hearings regarding the consent order process. To apply for a consent order, you and your former spouse will need to agree about what will happen with your finances. Once there is an agreement, your solicitors will be able to prepare a draft of the consent order that puts the agreement into the correct legal wording. And once your draft consent order and statement of information have been filed with the court, and the divorce has reached the decree nisi stage that I was just talking about, a judge will then review the draft order and the information. Provided that the judge is satisfied that the draft order is broadly fair, it will then, generally speaking, be approved. Once a draft order is approved, it's completely legally binding and it can be enforced if you or your spouse were ever to do something that is against the terms of that order. Okay, just briefly now, the court process. So what happens if you are divorcing and don't agree what should happen with the finances? So sometimes it's not possible to reach an agreement about finances. Formal court proceedings about financial issues can be very expensive, and it's therefore generally a good idea to see if you can make progress via other methods, such as mediation. Briefly, the court process, looking at financial issues, one person will send the form to the court. Both people will then be required to exchange all their financial information. So bank statements, pension statements, anything with any value, as well as pay slips, full details about income, and other documents that relate to debts. So again, credit card statements, loan statements, those kind of things. There'll then be a first hearing. Generally speaking, that will just be about timetabling the case. There'll then be a second hearing called an FDR hearing. That stands for Financial Dispute Resolution Hearing. And that is really a hearing just about negotiating and seeing if the two people can settle. If that hearing isn't effective, then there'll be a final hearing, and it's at that final hearing that a judge will make a final order. So it's really important to understand that a settlement by a consent order that we were speaking about just a few minutes ago can be reached at any point until the final hearing has started. So moving on now, just to financial issues for unmarried couples. So if you're not married, this is generally speaking the important information regarding finances. Perhaps the most significant thing to understand is there are no automatic financial claims between two people in a relationship if they are not married. The concept of a common law marriage is a myth. Normally, though, the main issue facing a separating unmarried couple will be what happens to the home. So when a property is purchased by more than one person, there'll often be something called a declaration of trust, which is a kind of document. A declaration of trust is an extremely important document. A declaration of trust is legally binding, and it sets out how the equity in a property is owned. So if a property is sold, what happens to the proceeds? Sometimes the declaration of trust is included in the property transfer form. That form is called a TR1. Okay. If there is no declaration of trust document, then the issue of who owns what percentage of the equity can become very complicated and legally quite complex. If there is only one legal owner, then the presumption generally will be that they own all the equity, but it can be more complicated than this, and the other person can still claim a share in the equity in certain situations. If there are two legal owners, then the presumption will be that they own the equity in equal shares. But it can, again, be more complicated than this, and either person can still claim a greater share in certain situations. If you are thinking of buying a property together and you're not married, having a clear declaration of trust can give you much more certainty. It's also something that the property solicitors, the conveyancers, should talk to you about if you are buying property jointly. A cohabitation agreement can also be prepared regarding other issues. A cohabitation agreement can also make it expressly clear that your partner will have no claim regarding the equity in a home you own. Sometimes solicitors will be asked to draft a cohabitation agreement where one person is living at a particular property and they get a partner who then moves in with them, and the person who is the owner is concerned that that partner may in future try and make some kind of claim about the property. So cohabitation agreements will often be drawn up in that kind of a situation. Okay. Again, another brief note here, just how wills and inheritance issues, very generally speaking, can affect unmarried couples. So if an unmarried partner dies...
Just pausing while we change interpreter. Sorry, my microphone was off. Okay.
Thank you.
Thank you, David.
Thank you so much. So again, just a brief note on how wills and inheritance issues, very generally speaking, can affect unmarried couples. So if an unmarried partner were to pass away and there's no valid will, then the surviving partner has no automatic right to inherit. So it's very, very different if your partner passes away and you're not married to if they pass away and you are married. Okay, so moving on now to the second part of the presentation, and this is about, generally speaking, the main points to understand as far as the law goes in relation to children. We'll look at some key concepts and just generally what the important factors are that a court applies when looking at any disputes with children. Okay. So, as I said at the beginning of the presentation, there can be all kinds of disputes about children. Some of the main ones that we encounter in practice will be, number one, the amount of time each parent has with a child. Those kind of situations are called child arrangements. Number two, what happens if one parent, say, wants to relocate to a different country? That could also be a relocation a long way away in this country. There are very similar principles that apply. Number three, as an example, what happens about important issues like which school a child attends and what medical treatment they receive, if there's any kind of a disagreement about those things. So disputes about children can be very difficult, they can be very emotional, and they can be very stressful. The court will always prioritize the child's welfare, and that will be the number one priority. When the court considers any issues about children, it will focus on the following factors, which is known as the welfare checklist. And again, this relates to the overwhelming need to look at what is in a child's best interests. So the first point, and this is the exact wording from the relevant law, the first point is the wishes and feelings of the relevant child. And those are considered in the light of that child's age and understanding. So that's a really important one where you have children who are, say, 12, 13, that kind of age, where often they'll be quite mature, they'll know their own mind. When children get to that kind of age, generally speaking, their wishes and feelings will have much more weight than, say, a 4 or 5 year old. So it's just kind of common sense type things, really. The second point, the second factor when looking at welfare is the physical, emotional, and educational needs of that specific child. The third point would be the likely effect of any change in circumstances. So if we were thinking about the situation where it might be that one parent wants to relocate, it's what the effect of that change might be on the child. That's going to be really important. Okay. The fourth factor is the child's age, sex, background, and any characteristics that the court considers relevant. So that can also include things like whether the child has, up to a certain point, been brought up in any particular religion and other things of that nature, heritage, cultural, etc., etc. The fifth point, and a very important one, is whether a child has suffered any harm or would be at risk of suffering any harm, which is extremely important. The sixth factor is how capable each of a child's parents are, and any other person basically who is, up until that point, a very important one in the child's life, how capable those people are of meeting that particular child's needs. And you also have to take into account what powers the court has as a final one. So generally speaking, where two people are married, they will both have parental responsibility for their children. And being the kind of so-called birth mother, that won't carry extra weight regarding welfare decisions in and of itself. Parental responsibility is a key concept in children law, and it means all the rights, all the duties, powers, responsibilities, and authority which by law a parent of a child has in relation to a particular child. When looking at financial issues following a divorce, again, the courts will deal with those kind of cases in the same way, and that's regardless of orientation and again who the birth mother of a child is. Maintenance for children, as in kind of child maintenance, is generally dealt with separately outside of the court system by the Child Maintenance Service, known as the CMS. That being said, in certain circumstances, it is possible to apply for financial orders on behalf of a child. That concludes the presentation. So I'll just hand back to Manuela just as we do the transition to the next bit, to the question and answer stage. Thank you again, everybody. And hopefully that was informative and you might have some questions now following off the back of it. Thank you.